Afternoon.
Hi, how are you?
I'm good. How are you?
Good. Good.
Mr. Tuckle, I think you're muted.
Uh,
Oh, now I can hear you.
oh, okay. Yeah.
Uh, I know we're a few minutes early, but are we good to start? Are we waiting for anyone else?
I
Nope.
think my client representative is going to join us, but I don't know that we need to wait for him.
We can wait until 2 o'clock just in case. But how's everyone enjoying their summer?
Been busy.
Yeah.
Super busy. So super kind of crazy busy. Yeah.
I remember when things used to slow down in the summer, but that hasn't been the case right now.
Yeah. It's a beautiful day today.
It was very cold yesterday. It got a little cold yesterday.
I prefer that to too hot myself.
Yeah.
It's been a hot summer, but we've managed to avoid some of the worst harsh weather that other parts of the country have had.
Mhm.
Yeah. That is
Mhm. So how about you, Judge Patel? Have you been busy? Lots of
true.
stuff?
I have been busy, but good busy. It's I'm still learning how to fit the Court of Claims into my Court of Appeals uh, schedule. So I think each month I get a little, little better at it.
Good.
Okay, we may as well start now. I'll call the case. This is Kemeter versus the Board of Regents of the University of Michigan, case number 22-94 MK. This is the scheduled pretrial conference. If I could have the lawyers put their appearances on the record for me.
Robert June for plaintiff.
Daniel Tuckle on behalf of the defendant, University of Michigan.
Well, hello. Thank you for coming this afternoon. I would like to get a sense from both of you about where the status of this case is, if there have been any mediation or negotiation efforts, or whether we need to proceed to setting this case for trial.
There was a facilitation earlier on in the litigation. Bob and I have had a number of cases of this sort over the years, so I think we know each other reasonably well. We were fairly far apart at the time that the facilitation ended. Since that time, we have filed a motion for summary disposition, which was denied by Judge Shapiro. We believe using the wrong standard of review. So that's one of the things I think has to be, or at least would make sense to revisit before trial. So that's where things stand. I don't know that any further mediation efforts will be productive just because of how far apart we were and the current status of the case.
Okay. Mr. June, do you have anything to add to that?
Yeah, we'd be open to any kind of, I make my clients participate. And so we'd be open to any kind of facilitation. I think Dan so we're in an awkward position regarding what this case is. So I take the position that it's a contract case. We go to trial. Breach of contract is what it's about. Dan's view is that it's a review proceeding similar to an ERISA case, but it's not an ERISA case, but that there is a limited review. In other words, that you could overrule the claims administrator only if you found their decision to be arbitrary and capricious. That was rejected by Judge Shapiro. Frankly, I was a little surprised that there was no effort to seek leave to appeal to the Court of Appeals on it. And so now Dan has basically told me that assuming we win at trial, there will be an appeal on that issue, which is all fine, but I'm not sure I want to spend the money on trial if that issue's hanging out there. I would rather have him appeal now and see what happens. rather than spending the money on doctors' depositions galore and things like that for trial. But that's, I don't know what procedure we would follow to get there. So as far as I can tell, we're headed toward trial right now.
So it sounds like, Mr. Chuckle, from the comments that you made earlier, that standard of review is something that you wish to have revisited again. I don't know that I have the authority to do that as the trial judge to revisit Judge Shapiro's order, but I haven't taken a look at it. Do you have arguments that would allow me to look at it, or is this something that the Court of Appeals would have to determine?
I believe that you have the authority to revisit a prior order of the court, even though it was a different judge, just like Judge Shapiro, had he still been handling this case, would have had the option of revisiting one of his own earlier rulings had he chosen to do so. So I think you have the authority. In terms of a vehicle, I think it would have to be maybe one of two things, either sort of a leave to file a delayed motion for reconsideration or leave to file a renewed motion for summary disposition. I think there are some arguments to be made that are a little bit different than the original arguments made to Judge Shapiro, but I do think that's the issue. And frankly, that is part of what's awkward to try to resolve the case at this point with that ruling holding, which essentially says there will never be a case involving long-term disability, denial of long-term disability benefits for the university where it would ever be appropriate to grant summary disposition. Because essentially what Judge Shapiro said is, if there's a dispute among physicians as to whether or not the person is disabled as defined by the plan, then it's inappropriate to grant summary disposition. And there is always a disagreement among physicians because in order to apply for disability benefits, the claimant has to submit something from a treating physician saying that she or he meets the standards for benefits. So if you don't have that, it never goes anywhere further. If you do have that and benefits are granted, it never goes any further. The only circumstance in which there may be a challenge is if the claimant submits something from a treating physician or physicians saying, yes, this person is disabled, and the plan administrator has medical evidence that disputes that, in which case the current ruling says, then it's not appropriate for summary disposition. So I think it's an unworkable standard, and I don't think it's the appropriate standard. And frankly, one of the things that I don't think the judge addressed, I agree with Bob that what he said is, it's basically just a breach of contract case, and it will be decided under contract principles. If it is a breach of contract case, whatever the terms of the contract are would be applicable. And in this case, the contract says that the claims administrator has discretion to determine benefits. That would be a term of the contract. And I don't think that the judge considered that. I think he basically said, well, if it's a contract and there's a dispute as to whether the person is disabled, then it goes forward to a trial. And I don't think he considered what are the terms of the contract. And I think if it's a private contract, it's not subject to ERISA, which we agree. It's not an ERISA claim because the university is exempt from ERISA as a public employer. Then you can set the terms of the contract, and I don't think there's anything to preclude them from saying that we're going to apply an arbitrary and capricious standard to a review, or whatever court or reviewing party is reviewing this. That's the subject that's a standard that they're entitled to. To me, it's sort of similar to, for example, a bonus contract for a company's executive that says you'll be eligible for a bonus, but it's awarded at the discretion of the employer. Those are held to be enforceable. And this would essentially be the same thing. You can get benefits, but it's whether you get it or not is at the discretion, which is reviewed under this arbitrary and capricious standard by the claim administrator or by the court in review.
Okay, so what I'm getting from the statements that both of you have made to me today is that it's really important to get the standard of review issue resolved before proceeding to a full-blown trial. I'm inclined to allow Mr. Tuckle to file a renewed motion for summary disposition. But I also want to very candidly put out there that unless there is a legal justification presented allowing me to go into Judge Shapiro's legal determination and clarify it or carry it forward some way, I'm going to be very reluctant to going back into his order and changing it, just because I don't want there to be a perception that with a new judge there's a new ruling. But so I see two avenues. There can either be a delayed application for leave to appeal to the Court of Appeals while the case is stayed, or I can allow you to, if you feel that there are arguments that will allow me to consider the issues in a novel way, or if there's a tangential issue stemming from the prior order, you can file a renewed motion for summary disposition. I can rule on that, and then we can proceed from wherever things go from there. Is there a preference from the parties about which of these two options you prefer?
I'd like the chance to discuss it with my client. My own personal preference probably is to renew it before you, because at this point it would be a delayed motion for interlocutory appeal or for leave to appeal, and it's so delayed that I think the chances of the court, they're always a little bit more difficult when it's an interlocutory appeal, which is why we didn't seek it. But now it would be even less likely, I think, just because of the delay. And so, if the application is denied, we're going to end up right back in front of you.
Mr. June, is that an amenable resolution?
Yeah, so the thing about the previous motion was it was a motion essentially for judgment as a matter of law on the whole thing. It wasn't partial. Which meant that we had to argue the facts as well as the procedure. I think Mr. Tuckle, if he does find that way to go, it might behoove us if he filed a motion for partial summary disposition on the issue of what the procedure is, rather than getting into the facts too. But it's okay to go the other way. It's just that it seems to me like we need to figure out if you were to decide his way on the procedure, then we know where we're going with the briefing from there on. If you decide my way, then we know where we're going with the trial.
You mean just motion just limited to the standard to be applied?
Standard and procedure. So is this a review procedure, or how, so that, yes, what is this? What is this, Dan?
Yeah. I don't object to that. I think, frankly, if the arbitrary and capricious standard is applied, it's a pretty straightforward argument at that point. But we don't have to address that right now. I agree with Mr.
Yeah. Okay, so then I will expect a renewed motion for summary disposition on the applicable legal standard for this case. What it would be a amenable briefing schedule that will work with your schedules?
Well, I know with summer, we have a couple of trips planned.
Yeah.
I'd ask for some reasonable amount of time. I don't know, 45 days, maybe.
Okay. I am not in any, if the parties, how about this? Why don't you and Mr. June confer together and come up with a stipulated scheduling order for the motion for summary disposition? And as long as the motion isn't going to be filed 2 years from now, I'll probably agree to it and sign the stipulated order.
What do you say?
Okay.
Half now?
I'm sorry?
How about a year and a half?
We may be cutting it close.
45 days, but not a ridiculously long time. But we'll discuss it amongst ourselves. We usually
Okay.
Yeah, we're good for that. Okay.
Is there anything else that we need to discuss before we adjourn for the afternoon?
I don't think so.
No?
I don't
Okay.
think so.
Well, good seeing you, gentlemen, and I look forward to getting that order from you soon.
Thank you, Ron.
Take care.
Okay. Thanks, Dan. See ya.
Bye-bye.